When statutory language is clear, and I'm going to make the point today, members of the committee, that the wording you will see is clear and it's unambiguous on its face. When it is, we must apply its plain meaning in its normal and accepted use without the forced interpretation. In that instance, we enforce the language without reference to a broader statutory intent, legislative history, or other sources. Now, I know that today you're going to hear many speakers comment on Jefferson said this, or the president said that, or the Supreme Court justice said this. I'm suggesting to you that while we can listen to those voices, they are irrelevant if the language is clear on its face. And I believe, respectfully, that there can be no dispute about what these words mean. So I wanted to actually take you through the process of looking at the actual United States Constitution, understanding things in its historical context, and I think we can determine that that is pretty plain. So here, I'll turn if you can hear me okay. So I'm going to go through these really quickly, and I've got to move in light of our time restrictions. What does the U.S. Constitution say about states' rights? Next, does the Constitution authorize states to assert their rights? That's what we're here about. Can states do something about our states' rights? Next, if so, then how does the state go about asserting its rights? Next, while not the exclusive means of enforcement, nullification, the very topic of this bill, is the least intrusive method of a state asserting its rights. Next, there are at least 10 provisions of the U.S. Constitution which are helpful and useful in analyzing the topic of states' rights. Next, due to time constraints, I will deal briefly with only 8. Next, before we look at the U.S. Constitution, we must understand that document in its place in time. Next, before the Declaration of Independence, they were colonies. There were colonial charters, and then there was England, the Parliament, and the King, who had control of this dirt that we have here. In 1776, the Declaration of Independence says that they've become independent states. Notice the transition. We are subjects of England. Now we're declaring independence. 1781, Articles of Confederation. There is a loose cooperative among the colonies at that time, which were newly declared states. And that document was in force and effect for a few years until 1787, in which the U.S. Constitution was proposed. And then in 1778, the U.S. Constitution was ratified by the 9th state. And then in effect, 1789 was the first year we made the Constitution operative. Next. So by reviewing this timeline, we can confidently establish the following 5 facts. Let's follow historical precedent here. The Declaration stated, and the resulting war for independence confirmed the principle of, quote, free and independent states, to wit, and here's our language, this is from the Declaration of Independence. We therefore, the representatives of the small u, it's an adjective, United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do in the name and by the authority of the good people of these colonies, they were colonies at that time, publish and declare that these united colonies are and of right ought to be free and independent states. State, capitalized, has a specific meaning. It's got to do with the sovereign. Nations today are nation states. They are sovereign. I'm suggesting to you something radical, something I did not learn in con law. The states are sovereign over the federal government. Now, take that and chew on it. That's what this bill's about. So, next, the second principle we can derive. These new states, which were declared free and independent, were first in time and first in right. Please understand the truth of this next sentence. No federal officer signed the U.S. Constitution because the federal government did not exist. Next, therefore, history confirms that the federal government is a creation of the people and the states. And we all know that the creator is always greater than the created. This is just simply logic. The states are first in time and first in right. Number 4, as a result, the federal government, that is, the thing created, has only those powers which were expressly granted to it in the U.S. Constitution. Next. Number 5, our Constitution didn't grant rights to the people. You know, let me pause. So many people say, I've got a constitutional right to this. You don't have a constitutional right to anything. You have God-given rights to things. The Constitution declares who has authority to deprive you of those rights and under what circumstances. That's the whole purpose of the Constitution and the law. So the Constitution, the government doesn't give rights, God does. When ratifying the U.S. Constitution, the people in the states created, notice the words there in white, they created a general, common, secondary government. And then they described the duties, powers, and limitations of that government. Next. So let's examine some of the duties, powers, and limitations of the U.S. Constitution. Next. Let's look at Article 1, Section 1. Next. I'm going to take you like elementary school students through this. So it's this plain. So we're going to go through it phrase by phrase. All legislative powers. Next. All means the totality of. Legislative means lawmaking. Powers means the ability to do or accomplish. Next. Herein granted. Next. That means, herein means, we can be Southern for a minute. In this here document, that's what herein means. In this here document, we have granted, we have given or authorized. Next. And then it says, shall be vested. So lawmaking powers that we're going to grant in this here document are vested in a Congress of the United States, which consists of the Senate and the House. Next. So shall be vested means must be held completely. Congress is the House, which was the House of Representatives, is the people's house. And originally, the United States Senate was the state's house. Those of you that are lawyers or studied the law, you may understand the 17th Amendment changed that and made U.S. senators subject to popular vote, but it was not always so. The two sovereigns, the two creators of the United States common government, the people and the states, each had a house. And they were to debate between each other about whether laws should be passed, and if so, how, and what were the effect of those laws. And they had to agree on those, and then it had to be approved by the executive branch, and then it became a law. That's the basic history of how bills are made, laws are made in the United States Congress. And so each of the sovereigns had a house in Congress, the people's house, and originally the state's house. Next. So here are our conclusions. Prior to the ratification of the Constitution, the federal government had no power because no federal government existed. 2, prior to the ratification, all power was vested in the people and the states. After the ratification of the Constitution, a federal government was created. After ratification of the Constitution, the people in the states they granted certain legislative powers to the federal Congress. Next. And then 5, since all legislative power was given to Congress, here's a shocker for many people, the president cannot make a law. He just can't do that. All legislative power was vested in the legislative branch. On a side note, same is true for Tennessee. All legislative power is in the General Assembly. The governor can't make a law. Next. And, surprise of surprise, courts cannot make a law. Okay? These are all logical things here that we need to understand. So, was the grant, when we gave all legislative power vested in Congress, was that power unlimited? Well, use your brain here. If we gave unlimited power, then the people of the states have no legislative powers left, since all legislative powers would have been given to Congress. Or perhaps our sovereigns in D.C. would be kind enough to allow us to decide some things. That's maybe the prevailing idea. We can do it if they say we can. Well, that's ridiculous. If there were legislative limits, then that's the question. Are there legislative limits? Yes. Then what are they and how do we know? Next. So, not surprisingly, the answer lies in the very text of the Constitution. Article 1, Section 8. Let's next, and then next again. Before we start on this, let me tell you, Article 1, Section 8 is not the entire scope of legislative power. Some amendments address some administrative things that the Congress can do. But Article 1, Section 8 is the central nervous system of the entire federal government. It's the brain, it's the spine, it's what communicates to all the arms and limbs and fingers and toes. And so we need to look, not exclusively, a few amendments do address some things, but primarily we look to Article 1, Section 8 to find out what the federal government can do. Notice the language here, Article 1, Section 8, I'm quoting, it says, the Congress shall have power to. And then note the similar language, just like in Section 1 we've just looked at. All legislative powers herein granted are vested in Congress. Next, we're going to go through a list. They're not numbered in the Constitution this way. I've grouped them to get them all on one screen. First, we don't need to write our congressman and tell them to do this. They know how to do those three things. They know how to tax, spend, and borrow without any arm twisting. Second, regulate interstate and international sales. We call that sometimes commerce, regulate commerce between the states and foreign nations and among the Indian tribes. Three, make rules for citizenship and bankruptcy. Next, they can coin money and punish counterfeiters. 5, post offices. Next, patents, copyrights, trademarks, they establish weights and measures for the country so that we're all together with the same measurements. 7, create courts below the Supreme Court. 8, rules of war and the U.S. military, they can make those rules. And then 9, they can make laws governing the United States land and property. And then notice this most important one. That's the end of the list. That's the full scope of the power that the states gave to the newly created federal governments to do the things that are there. Notice on number 7, we don't even have to have courts below the Supreme Court. Congress created those, and they did that. They did it lawfully. But all these multitude of federal courts we have, Congress created them. So the concept here is this is the total list of what the United States Congress can make laws about. Next. So the conclusion, the legislative power of Congress is limited. 2, Congress has no power to enact legislation, and legislation can be laws, rules, or regulations in any area outside the bounds of Article 1, Section 8. Number 3, the people in the states retain the power to make legislation in all other areas. Next. Now let's look at Article 2. Article 2 of the U.S. Constitution is the executive branch. And notice it talks about power here. Executive power shall be vested in a president of the United States of America. Next. Here are the conclusions. The president has no legislative powers, but only executive powers. Next. Executive powers relate only to the duties to carry out or implement federal law. Let me pause on that one for just a minute. I'm going to face the committee members. When I give my presentation, I tell people, here's the job of the executive, the United States president, a county mayor, or the Tennessee governor. And I hope I'm not departing from decorum, but I'm going to stand and show you something. If I'm the executive and there's a law passed, my duty is to stand and face the lawmakers and salute and say, yes, sir. I carry out the law that was passed. That's the sole duty, except for a few other things about approving bills and directing the military and so forth. The executive follows the law and implements the law and carries out the law. That's the very plain meaning of what executive powers are. Next, 3 there. Because the executive's powers are limited to the execution of federal law, the president does not have power to execute any law that falls outside of Article 1, Section 8, because Congress cannot make laws beyond Article 1, Section 8. So therefore, he doesn't have anything outside that area to execute. Next. The president has no power to restrict the rights and powers of the people of the United States other than by laws authorized by Article 1, Section 8. Next. The president is the chief executive, and he is over all the executive departments and agencies, all the alphabet soup that we have on both state and federal level. He's the chief executive. So if he's the chief, then no federal agent has greater power than the president. They can't have more than he has. Next. Therefore, number 6, no member of the executive branch may restrict the rights and powers of the people of the states other than by laws authorized by Article 1, Section 8. As you can see, Article 1, Section 8 is the total power. Next. Therefore, we can conclude, and here's a shocker for many people, executive orders. Do we have to follow that executive order? Well, listen, friends, I'm going to tell you. Executive orders are not called executive orders because they're issued by an executive. They are called executive orders because they bind only the executive branch. An executive order only applies to the people under his control. The people are not under his control. The General Assembly, the Congress is not under his control. The courts aren't under his control. An executive order only controls the executive branch. It's very plain. There's misunderstanding about this topic all across our country. Next. Now let's look at the courts. The states gave the judicial power to one Supreme Court and in such inferior courts as could be later ordained and established. Look at section 2. How far does the judicial power go? It shall extend to all cases. Notice the word case is important. What is a case? That's where there's party A and party B, and sometimes C, D, E, and F. But their authority extends to a case that's before it. And what cases can it hear and decide? Cases in law and equity, but those cases must arise under this Constitution or under the laws of the United States and treaties made, which are made under their authority. Again, Article 1, Section 8 limits the kind of cases that the federal courts can hear. Next. So conclusion, courts have no legislative powers, but only judicial powers. Judicial powers relate only to the duties of rendering a judgment in a particular case. That's what judges do. They decide who wins and who loses. Number 3, because judicial powers are limited to cases under the Constitution, the federal courts do not have power to judge any case whose subject matter lies outside of the scope of Article 1, Section 8, since Congress cannot make laws beyond the scope of Article 1, Section 8. Thus, federal courts have no power to restrict the rights and powers of the people or states, other than by laws that are within the text, the subject matter, the scope of Article 1, Section 8. Next. Now, here's another shocker. Nowhere in the text of the Constitution are courts given the right to interpret the Constitution, nor are the courts given the right to declare what is constitutional. I want us to stop right there for just a minute. The typical member of the American public, and I'm afraid even the typical member of the bar, thinks that the main reason we have a United States Supreme Court is to tell us whether something's constitutional. We even had a Speaker of the House a decade or so ago that said, we've got to pass the law first to find out whether it's constitutional. That's utter nonsense. Nowhere in the Constitution is the Supreme Court given the authority to declare what is constitutional, nor is it given the right to interpret the Constitution. So we ask ourselves the question, how'd they get that right? Next. Well, in support of my proposition that they took this right for themselves, a pure power grab, I will quote to you, as you know, the extreme right wing, Justice Sotomayor of the United States Supreme Court. A fellow right winger like me. Well, I say that in jest. She is not right wing at all. She's from the liberal establishment of the court. I want you to hear what she said in the case that overturned Roe versus Wade, the Dobbs versus Jackson. Here's a quote. She says, counsel, she's arguing with the counsel that's trying to overturn Roe versus Wade. And so by way of argument, she says, there's so much that's not in the Constitution, including the fact that we have the last word. Marbury versus Madison, the case where they took the power. There is not, her quote, there is not anything in the Constitution that says that the Supreme Court is the last word on what the Constitution means. It was totally novel at that time, and it was. And yet, what the court did was reason from the structure of the Constitution that that's what was intended. You understand what she's saying? We used our brain to decide we could do that. Someone needs to decide. So what I say in my presentations, they say, mirror, mirror on the wall, who's the wisest of them all? Well, it must be us. And so we'll decide. A raw power grab. That's exactly what they did. And they continue to do that. They reason from the structure of the Constitution. They've reasoned from the 14th Amendment and created a quagmire of nonsense through the incorporation doctrine. Another, for you lawyers, incorporation doctrine, totally made up. Has no basis in the Constitution, has no basis in reason or in a republic, quite frankly. Anyway, they reason from that. So next slide. And I was going to let you hear it in her words, but we may not be able to get that to play. So I think if we can't get it to play, we'll skip it. If you want to hear it, you can hear her say that in her own words, admitting that there's no authority in the Constitution for the courts to decide that. So let's move on our slides. Each of the first 3 articles of the Constitution make it plain that the states did not give up all rights to the federal government, a government which the states and the people had created. Next. Is there any other evidence we need to consider in evaluating whether states are supreme? Do they have rights? The answer is yes, the Bill of Rights. Next. So next. The preamble is one of the things. I've got a pocket constitution here with the Declaration. It's got the preamble to the Bill of Rights in it. Many of these documents do not put the preamble in. I never studied it in law school. I want you to look at what the preamble to the Bill of Rights says. Why are we doing a Bill of Rights? Look at what it says. It says the conventions of a number of the states having, at the time of adopting the Constitution, expressed a desire. Hey, are we going to adopt this Constitution? I'm concerned about something. They expressed a desire in order to prevent misconstruction or abuse of that's the Constitution, the Constitution's power, that further declaratory and restrictive clauses should be added, as extending the grounds of public confidence in the government will best ensure the beneficent ends of its institutions. Stay on that slide for just a minute. Let's go back there. Notice what it's saying here. Why do we have a Bill of Rights? Because we want to be sure there's no playing around with the language of the Constitution. We want to be sure that it can't be misconstrued. We want to be sure that the federal government is restricted. Notice restrictive clauses. Next. Note this. According to the preamble, every single one of the 10 Bill of Rights was adopted in order to limit federal power. The intention was not to protect any or ensure any particular right, not your right to have a gun, not your right to have a free press. It's to tell the federal government they can't touch it. That's the whole purpose of the Bill of Rights. The intention was to protect that right from federal intrusion. That means the states would decide those issues. Next. Now let's look at the 9th Amendment. And I'm making good progress. Thank you for your patience. The enumeration, here's what the 9th Amendment says. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained, notice the word retained, by the people. Next. 10th Amendment. The powers, 9th Amendment again, is the rights. If the right is not specifically in the Constitution given to the federal government, it's reserved or retained by the people. 10th Amendment. The power, if we did not give power, okay, 10th Amendment is a power. The power is not delegated to the United States by the Constitution, nor prohibited. Now, the Constitution does in some cases prohibit the states from doing certain things. Look at the Article 1, Section 10 for you lawyers. Article 1, Section 10 is the list of things states can't do. They agreed to give up certain powers. If it's not in there, then those things unstated, if it's unstated, they're reserved to the states respectively or to the people. Next. So the 10th Amendment analysis. The 10th Amendment sets in concrete the framers' view of the covenantal nature of government, by which government has only such power as we the people delegated to it through the written document, through the Constitution. Next. So in conclusion, it's very clear from these 7 constitutional provisions that states' rights exist. Surely, in light of this clear language, no one could argue otherwise. Right? Next. Wrong. There are 2 main arguments against what I've just told you. I only have time to make one today. That's the Supremacy Clause. The other one's the 14th Amendment. I wish I had an hour. I could really, I think, open your eyes to that. But I'm telling you, if you really want to know, come and ask me and I can show you from the very text. What's the Supremacy Clause? Some people say, don't you know our Attorney General in Tennessee? I don't fault him. He went to law school, same type of law school I did, same kind of wrong and bad education that aggrandizes the federal government. But it's just wrong. So, don't you know, people say that the Supremacy Clause makes the federal government supreme over state governments. Next. Well, those who think the Supremacy Clause makes the federal government supreme over the state governments just haven't read the Supremacy Clause. This is how simple it is. Let's read it. Next. Here it is. By the way, you won't find it labeled the Supremacy Clause. It's hidden in there. You've got to go looking for it. It's in Article 6, Paragraph 2, and here's the actual language that scholars call the Supremacy Clause. It says, this Constitution, remember, what's a Constitution for? It's a document of limitation. It's about a general government. It's about specific powers. We're going to limit it beyond that. This Constitution and the laws of the United States, which shall be made in pursuance thereof. So the laws are bound by the Constitution. We already learned that in Articles 2 and 3, right? All treaties made or which shall be made under their authority, under the authority of the United States, shall be the supreme law of the land. So what's the supreme law of the land? The Constitution, and then laws that are properly made and treaties that are properly made. Not a single word about court opinions being followed, being the supreme law of the land, but it does address the courts, and it says the judges in every state are bound thereby. What are they bound to? The Constitution. What Constitution? They're bound to the rules of the U.S. Constitution and its limitations. anything in the Constitution or laws of any state to the contrary notwithstanding. You can ignore Tennessee's Constitution if the federal Constitution gives it to the federal government. If it doesn't, the states still have the power. Next. So let's analyze. The Constitution is the supreme law of the land, not the federal government or the U.S. Congress or even the U.S. Supreme Court. Next. I'm here to tell you it's possible for federal law to become the supreme law of the land, but only where the subject of that law is contained in Article 1, Section 8, and again, a couple of other ambiguous, obscure places in the amendments, but that's the primary place. So since the Congress has no power to enact a law which is not authorized by the U.S. Constitution, no law can become the supreme law of the land unless its subject is expressly set forth in the powers granted to Congress. What do the 9th and 10th Amendments say? If it's not in the Constitution, given to the federal government, the people in the states keep it. So, stated another way, once the federal government was created, the Constitution went on to limit the scope and power of that general common government, and the Supremacy Clause stands in support of those limitations. Next. Therefore, the action of any federal officer is legitimate only where the subject of that action is authorized by Article 1, Section 8. Any law, executive action, or court opinion regarding a subject which is not expressly authorized under that statute or under that section is not the supreme law of the land. In fact, it's not even a valid law or a valid use of governmental power. It's been called void ab initio. That means it's void. It's not that we overruled it. It was never a law at all because they went outside the rights. So I'm here to tell you, actually, the Supremacy Clause is on our side. It's on the side of states' rights. It gives us 8 provisions of the U.S. Constitution which support the existence of states' rights. Next. Now, our question, how do we, if we have the rights, how are they enforced? The primary means whereby a state may enforce its rights, short of secession. Seceding is a way to do it, right? If I'm in a contract with somebody and they don't keep the contract, I can say, well, the contract's over. I'm done. I'm leaving. Forget it. We don't want to do that. I think we need to work together for common general things. And that's the idea here. Short of secession or military action, we have to do it through nullification. Next. Nullification is the means whereby a state claims the federal government has ceded its authority and thereby makes an assertion that it's not bound by any federal law, decree, judgment, or the like. Next. Nullification is not anarchy. You're going to hear people say, this will lead to anarchy. This will lead to rebellion. Let me tell you, nullification is the lawful means whereby we reestablish the rule of law by telling the people that are ignoring the compact, you're out of line. Nullification is the means by which we reestablish the rule of law by ignoring the actions of the usurper. Usurper is someone who takes power they weren't given. Or they could be an anarchist or a rebel. Next. Now, I hear some people argue that states can't use nullification until a U.S. court says they can. We can't do it because no federal court's given us permission. This view ignores the fact that courts don't make law, legislatures do. So federal courts have no means whereby they may validate or invalidate the actions of a sovereign state, since the people in the states did not give federal courts that power in the Constitution. Next. Others say, here's another argument, well, nullification is not mentioned in the Constitution. Guess what? That's technically true. But that statement's misleading. The Constitution specifically states that all rights and powers not mentioned, that is, enumerated and delegated, are specifically reserved to the states and to the people. The right to nullify and or federal or international, by the way, we've got international laws that are coming on the scene I'm very concerned about. What are we going to do when that happens? The rights to nullify those federal and international laws, rules, judgments certainly fit within the meaning of the 9th Amendments and the 10th Amendments. Next. And then lastly, let me tell you, it would be absurd and contrary to everything understood under the law for a sovereign who was first in time, who is first in right, who created the federal government. We're the sovereign. We would have to be required to get the permission of an inferior in order to act. In fact, one could rightly conclude that no right exists where you have to seek permission to exercise it. Thus, it is possible for the Constitution, for the Constitution to reserve a right within the power of the people or the states, while at the same time requiring the state to get the permission of the federal officer. It's impossible for it to be So, a brief story. I've got about 10 slides left. I had a conversation with an attorney, Northeast Tennessee. and we were discussing this idea. He said, some legislature up here in Kingsport, he was talking about Representative Halsey. He says, he's proposed this ridiculous idea about nullification. Okay, and he was talking to me. He didn't know I had a role in that. And this ridiculous nullification thing. And I said, let me ask you a question. Do you believe that there is such a thing as states' rights? And he said, yeah, I guess. I said, okay. If there are states' rights, what are they? And he goes, I'm not sure. I said, how would we know? Where would we look? And he said, rightly, I guess we'd have to look at the Constitution. And I said, right, that's correct. We would have to look at the Constitution. And here's the next question. If we look at the Constitution and we find out that it's not authorized for the federal government, who has the power to say so? And then he got really quiet. Oh, this is solely about who has the power. And states quiver and quake under the threat of pretty much, unfortunately, federal dollars. We quiver and quake under federal dollars, and we sell our rights. We give away, we're Esau, selling our birthright for a mess of pottage because we're afraid we won't get federal dollars. And we give up our rights and the rights of the people to do that. And we shouldn't do that. And so here's what's happening here. So look at this. Nullification is among the unalienable rights that are granted by Almighty God. The only question remaining is how do we go about it? The answer depends upon the various circumstances. Next. So our bill here basically says here are the ways we do it. First, the lawmakers can enact a law that says the federal action is to be void. Now, what's that mean? We leave it up to the General Assembly to decide what that means. Read the bill. Senator Bowling's bill basically says that you get to decide the penalties, if any, what powers Tennessee is going to take. Remember, this bill does not nullify anything. It simply says how it is to be done. And one way to do it is that one branch of our state government can do it. We can say, that's not valid. Federal government's out of bounds. We don't have to follow that. Second, an executive. So the governor can say, an executive order, under my administration, under my executive branch, all agencies of the state are not to follow, or maybe we're going to obstruct, or maybe we're going to oppose. That's up to the executive to decide. And third, courts can issue an order that says, in the case before me, that party's not guilty. The federal government doesn't have a right to make that law. Not guilty. The court's got a right to do that. That's nullifying with the branch. This is not, by the way, as our Attorney General said, we're messing with separation of powers. There's no separation of powers problem here. The lawmakers take care of the laws. The executive takes care of the administrative agencies in the state. The courts take care of the court cases. That's what they're supposed to do. Or number four, we can use any combination of the above. Next. I want us to take just a moment, and I mean just a moment, to look at what the Tennessee Constitution says. You're going to see something startling here in these next slides. Next. Tennessee Constitution, Article 1, Section 1, right after our preamble, says that all power is inherent in the people, and all free governments, free government? What's a free government? Well, Declaration of Independence says free and independent states. All free governments are founded on their authority, instituted for their peace, safety, and happiness. For the advancement of those ends, they have at all times, they the people have at all times, an unalienable and indefeasible right to alter, reform, or abolish the government in such manner as they, the people, may think proper. And then notice the next section, Section 2. That government being instituted for the common benefit, the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. If we don't resist, our Tennessee Constitution says, if we don't resist those people who take arbitrary power, they make up the rules, they reason to conclusion from the Constitution, and their reasoning happens to lead to a power grab, more things that they can decide, more things that they can do, more power that they can wield. When they happen to do that, are we at their mercy? No. In fact, we are absurd, slavish, and destructive when we sit on the sidelines and don't do something about it. That's specifically our Tennessee Constitution. And then next slide, I want you to notice, this is extremely persuasive. Consider the historical precedents of the adoption of the Tennessee Constitution. As stated in our very own Tennessee Blue Book. You guys have one? Hope you do. Go back and look at your Blue Book. Next slide, you're going to find this is what it says. It says the first Constitution of the state of Tennessee was written in Knoxville during the winter of 1796. The year the state was created, from the geographic area known as the Southwest Territory. Look at this. The first Tennessee Constitution was not put to a vote of the citizens of the new state for ratification, but was approved by Congress. You hear that? The people didn't actually ratify it. The state's version of the Continental Congress approved it. They sent it to D.C. and said, we want to be a state. And so D.C. looked at Tennessee's Constitution and says, we accept you under these terms. They ratified our state constitution, the federal government. That's shocking. Next slide. You may wonder why this historical point is significant to the topic of nullification. The answer lies in the language that Congress approved. Next. This is what our Tennessee Constitution says. We, the people of the Southwest Territory, having the right of admission to the general government as a member state thereof, consistent with the Constitution of the United States, the general government, we're going into the general government, that's consistent. We did, blah, 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 1796, ordain and establish a constitution or form of government, and look, mutually agreed, who are the parties here, okay? We mutually agreed with each other to form themselves into a free and independent state by the name of the state of Tennessee. I want you to note, 8 years after the U.S. Constitution was formed, or was proposed, that Tennessee is submitting a constitution to Congress saying, we, Tennessee, want to come in as a 16th state, and we still claim we're free and independent. And guess who said, I guess you're right. We'll approve your Constitution. You, Tennessee, are free and independent. What does that mean? That's what we've got to decide. If we're free and if we're sovereign, then we get to make the final rules. Next slide. Note the Tennessee Constitution repeats the language of the Declaration, free and independent state, and applies that status to the new state of Tennessee. Next. So when Congress ratified the Tennessee Constitution, it approved Tennessee's admission to the general government as being consistent with the U.S. Constitution, while also acknowledging that Tennessee remained free and independent. We're free of what? Free of anything. We can do whatever we wish if it's not in the U.S. Constitution. We're independent of what? Independent of the federal government and independent of the other states. We don't have to follow what other states do. We're free and independent. Independence is a wonderful thing. It's what liberty's about. Okay, I want liberty. If we said we're dismissing this and people are at liberty, we wouldn't all go to the bathroom at the same time, all go to eat at the same time. We're at liberty. States are at liberty to wander, W-A-N-D-E-R, among all the other rights and things that they want to do if they're not bound by the U.S. Constitution and by God's law. They're free to wander among those. But the scholars of today don't seem to understand that the U.S. Constitution is clearly a compact between the states. They don't understand that. This is a deal between the 13 colonies, and Tennessee got in on it later. If properly acknowledged, this fact would prove the superiority of the rights and powers of the states, except were expressly delegated to the general government. Next, I want you to note this quote. We are under a constitution, but the Constitution is what the judges say it is. That's a quote from New York Governor Charles Evan Hughes in a speech to the Chamber of Commerce over 100 years ago. Hughes later served as U.S. Supreme Court Chief Justice during the Coolidge and FDR administrations. I'm here to tell you, Evan's view is what the court presently says. That's the prevailing view. But that is not supported by one word of the Constitution. Next. The end, wait for it, next, is near if we don't stop the tyrants. Thank you.
Okay, thank you. I think